says it's impossible for judges to consistently apply a law that permits or prohibits conduct based on whether someone is a man or a woman. And you specifically cite bathroom laws as an example of this. In fact, you criticize the then Trump administration's designation of gender-based bathrooms. Right? Sounds like you've made up your mind on a lot of things, but I just want to get clear on this because this is an important issue, certainly to people in my state.
It's very
you think that bathroom designation, same with locker rooms, I guess, girls' locker rooms impermissible. Biological men have to be permitted into girls' locker rooms.
After watching that exchange, I have to say Senator Hawley looked far more prepared than the nominee expected. Agree with his politics or not, he came with receipts. He wasn't asking random, hypothetical questions. He was quoting directly from an article Judge Wise wrote while serving on the bench. What immediately caught my attention was the gap between what Hawley read from the article and how Judge Wise explained it during the hearing. If someone has publicly written about major constitutional issues, I think it's completely fair to ask whether those views still reflect how they would rule today. That's exactly what a confirmation hearing is for. Some people will say Hawley was too aggressive. I see it differently. Federal judges receive lifetime appointments, so senators should ask tough questions. If a nominee struggles to clearly explain past writings, that's worth examining. Before we break it all down, let me know what you think in the comments. Did Hawley fairly represent the article, or do you think Judge Wise was misunderstood? If you enjoy reactions to major political hearings like this, hit the like button, subscribe, and let's get into it.
Thank you very much.
Senator Kennedy.
I'd like to allow Senator Hawley to go.
Well, that's very nice of you. Senator Hawley.
Thank you, Senator Kennedy. Thank you, Mr. Chairman. Congratulations to all the nominees. Thanks for being here. Judge Wise, let me just start with you. So as I understand it, you don't think that there really is any clear-cut distinction between male and female as biological categories. Is that correct?
That is not correct.
That's what you wrote.
Sorry, that is not correct.
Well, that's what you wrote. Look, I'm reading your article, your Time Magazine article. Just to be clear, you wrote this while you were a sitting judge, 2017? You were on the bench?
That is correct, after a case I had.
Right. So, interesting choice to be writing opinion pieces about your cases, but in any event, you say that controversial pieces of legislation enacted in the last 2 decades rely on a clear-cut interpretation of sex, what I just asked you, but you say that that's wrong. In fact, gender is an intricate continuum and not 2 tidy boxes. That's what you say. So have you changed your opinion? You just gave me a different answer.
I believe that generally speaking, there are 2 sexes, male and female, that are designated by a doctor at birth, and that applies to the vast majority of people.
But that laws that are based on that distinction are impermissible. That's what you say in this article. Is that correct? That's still your view?
That is not what I say.
Really? You say that if there is, for instance, a law that requires a distinction between male and female in bathrooms, that the judges cannot apply that law with any consistency, can't apply it consistent with equal protection. There are no, what is it? It's virtually impossible for judges to consistently apply a law that permits or prohibits conduct based on whether someone is a man or a woman. So all bathroom laws that require biological sex, that designate bathrooms based on biological sex, are impermissible?
That is not the position that I took in the article.
That's what it says. It's impossible for judges to consistently apply a law that permits or prohibits conduct based on whether someone is a man or a woman. And you specifically cite bathroom laws as an example of this. In fact, you criticize the then Trump administration's designation of gender-based bathrooms. Right? Sounds like you've made up your mind on a lot of things, but I just want to get clear on this because this is an important issue, certainly to people in my state.
It's a very important issue.
You think that bathroom designation, same with locker rooms, I guess, girls' locker rooms impermissible? Biological men have to be permitted into girls' locker rooms?
That is absolutely not what I said in my
That is
article.
absolutely the import and the takeaway of your piece. You suggest at least 3 different constitutional problems with any gender-based laws, including specifically bathroom laws. You write about it. Equal protection violation, due process, void for vagueness, I was making a list as I was reading through. You say that our biological variability means that a two-bathroom, even two-sex-based approach is inadequate. Judges cannot apply it. So if Title IX is interpreted to protect women's sports, biological women playing sports with other biological women, it's unconstitutional?
Senator,
That's a yes or no.
I was referring to the 5 babies born a day that doctors have challenges.
No, you wrote an article that is extremely broad that pronounces on a range of issues and pronounces quite definitively. What's this comment at the end of your article about the fact that judges must see the world through a secular lens, and when legislators blur the lines of church and state to enact laws that permit or prohibit conduct based on biological gender as only male or female, they place an impossible burden on the judiciary? What's that mean? That distinctions between male and female are a violation of church and state?
Judges have to be able to administer these laws if the direction, and I have to tell you, I work really hard to get it right, to do exactly what Congress tells me to do and the legislature tells me to do. And as a result, if a doctor finds it difficult to identify at the moment of birth for certain children.
Is a law that distinguishes between male and female a violation of church and state? You say when legislators blur the lines of church and state and enact laws that permit or prohibit conduct based on biological gender as only male and female, they place an impossible burden on the judiciary. So this is a First Amendment violation?
If what you are telling judges is that in order
I'm
to
not
make-
telling you anything. I'm reading you your comments, and I am asking you if you are still committed to these, and it sounds like you are. I have to tell you, I think these positions are insane. I think the idea that laws based on the distinction between male and female are a violation of church and state is insane. Totally insane. I think the idea that laws that would say women's locker rooms are protected from biological men, that those are impermissible, that's insane. But that's what you say in this article. You're going to have to recuse yourself in a lot of cases, aren't you? Will you recuse in every case involving biological sex if you are confirmed?
Senator, respectfully, that is not what the article says.
You have pronounced on all of these issues. Will you recuse yourself in any case involving Title IX, biological sex, challenges to locker rooms, girls' sports, bathroom bills? All of those things are covered in this article that you wrote while you were a sitting judge. Don't you think that was impermissible? Will you recuse? Let's get an answer to that.
Senator, your time is expired.
Will you recuse?
I did not take a position as to those issues that you have raised.
You took a position on all of these things, and your position is insane, totally insane. I will absolutely not vote for you. There's not a world in which I could support you. I can't believe you have been nominated. And if you are confirmed, which I hope will not happen, you absolutely must recuse across all of these cases or stand in violation of the Code of Judicial Conduct. I'm shocked you're sitting here today.
Judge Weiss, you were unable to complete several answers. I'll give you that opportunity now.
Thank you. The thesis of the article, which begins right after the introductory material, that is the first sentence of the third paragraph, makes it absolutely clear that my article had nothing to do with people who are transgendered or gay. It dealt with a narrow issue about babies who are born where doctors are challenged making a determination about sex. And as a sitting judge who has to administer potentially laws where I would have to make such a determination that doctors sometimes find it difficult to do, I think it is critically important. It's important under the Constitution. It's an obligation that we have to treat everyone to have equal protection under law. It is the words that is listed above the entrance to the United States Supreme Court. I actually believe that everybody who is in here cares about all newborn babies and what the circumstances are for all of them. And for those children who eventually become adults, I believe that the legislatures and Congress need to help judges and give a clear indication about what to do in those limited instances. And that is all.
Senator Butler?
Now that we've seen the full exchange, I think Hawley's biggest strength was staying focused on one point. These were Judge Wise's own words. He wasn't pulling quotes from social media or relying on rumors. He was reading from an article she chose to publish while serving as a judge. If you're writing publicly about constitutional issues, it's only natural that those writings become part of your confirmation process. Judge Wise repeatedly argued that Hawley was misreading her article. That's possible. Legal writing can be complex. But if your explanation during the hearing sounds much narrower than what many readers took from the article, it's reasonable for senators to ask follow-up questions. I also noticed how Hawley moved the discussion from legal theory to real-world issues like bathrooms, locker rooms, Title IX, and women's sports. Whether you agree with his examples or not, these are real legal disputes that courts have had to address. It's fair to ask how a judicial nominee approaches them. Judge Wise responded that her article was actually focused on a very specific issue involving the small number of newborns whose biological sex is difficult for doctors to determine at birth. She insisted it was never meant to address broader debates about transgender policies. If that's the case, then I understand why she felt her article was being stretched beyond its original purpose. But I also think Hawley raised a fair point. If an article is meant to deal with a narrow issue, it should be clear enough that readers don't walk away believing it makes much broader constitutional claims. Another part that stood out was Hawley's concern about judicial impartiality. His argument wasn't just about the article itself. He questioned whether someone who has already written publicly on these issues could later hear similar cases without raising concerns about impartiality. That doesn't automatically mean a judge has to recuse themselves, but it's a fair question during a confirmation hearing. Public confidence in the courts depends on judges being and appearing to be impartial. Hawley's language definitely became stronger near the end when he called the positions insane. Some people will think that went too far. Personally, I would have preferred less rhetoric and more focus on the legal arguments. Even so, I don't think it changed the core issue he was raising. Judge Wise closed by repeating that Congress should provide clear guidance for judges dealing with rare intersex cases and maintained that her article had nothing to do with broader policy debates. Some viewers will accept that explanation. Others probably won't after hearing the passages Hawley highlighted. For me, this hearing was ultimately about accountability. If a judicial nominee has publicly expressed views on important constitutional questions, senators have every right to ask difficult questions and compare those writings with a nominee's testimony. Whether you agree with Hawley or not, this hearing showed why the confirmation process matters. Lifetime appointments deserve careful scrutiny, and the American people deserve clear answers.